Canadian legislative independence. When the Dominion of Canada was created in 1867, it was granted powers of self-government to deal with all internal matters, but Britain still retained overall legislative supremacy. This imperial supremacy could be exercised through several statutory measures. In the first place, the Constitution Act of 1867 provides in S. 55 that the Governor-General may reserve any legislation passed by the two Houses of Parliament for the signification of Her Majesty's pleasure, which is determined according to S. 57 by the British Queen in Council. Secondly, S. 56 provides that the Governor-General must forward to one of Her Majesty's principal Secretaries of State, in London, a copy of any federal legislation that has been assented to. Within 2 years after the receipt of this copy, the British Queen in Council can disallow an act. Thirdly, 4 pieces of imperial legislation constrained the Canadian legislatures. The Colonial Laws Validity Act of 1865 provided that no colonial law could validly conflict with, amend or repeal imperial legislation which explicitly or by necessary implication applied directly to that colony. The Merchant Shipping Act, 1894, as well as the Colonial Courts of Admiralty Act, 1890, required reservation of Dominion legislation on those topics for approval by the British government. And the Colonial Stock Act of 1900 provided for the disallowance of Dominion legislation which the British government felt would harm British stockholders of Dominion trustee securities. Most importantly, however, the British Parliament could exercise the legal right of supremacy it possessed at common law to pass any legislation on any matter affecting the colonies.